Good morning. I'm Angela Nwachi-Willig. I'm Dean of Boston University School of Law, and I want to welcome everyone to our panel today. It's entitled Title VII Today: Continuing Issues in a Complex Workplace. First, on behalf of our entire panel, I want to thank Judge Victor Bolden for including this really important topic in the program of the Second Circuit Conference. I also want to thank Kimberly Harris from NBC Universal and Professor Deborah Archer from NYU School of Law for inviting and organizing this really, truly fantastic group of speakers for this panel. It's been a real honor to get to know them and to also learn from them as well. And there's been so much to learn from in 2019, 2020. And of course, last week we lost a legal giant who taught us so much about some of the topics that we'll address in this panel, and that was Justice Ruth Bader Ginsburg. And we'll discuss in this panel everything from Me Too and sexual harassment to the Crown Act, which is the act that protects against hair-based race discrimination, to COVID-19 and its implications in the workplace, to Bostik, and so much more. But first, let me very briefly introduce our panelists. Our first panelist is Charlotte Burrows, who is the commissioner at the Equal Employment Opportunity Commission at the EEOC. Our second panelist is Alfonso David, who is the president of the Human Rights Campaign. Our third speaker is Fatima Goss Graves, CEO and president of the National Women's Law Center. And last but not least, we have Betsy Plevin, who is a partner at Proskauer Rose LLP and also a BU Law alum. So I'm delighted to begin this panel. I want to start with a question first for Ms. Burrows. So on September 21st, 2020, the U.S. House of Representatives passed the Creating a Respectful and Open World for Natural Hair Act of 2019. That's otherwise known as the Crown Act. And before then, we had a number of states. We had California, New York, New Jersey. They were really the pioneers here who enacted their own historic versions of the Crown Act. Last month, for the first time, we had a U.S. District Court judge, Judge George Hanks of the Southern District of Texas, issue a preliminary injunction to Barbers Hill High School, allowing Caden Bradford, an African-American teen who'd been suspended from school for refusing to cut his dreadlocks or locks, a style that the school said was in violation of their grooming code. The injunction allowed him to attend school with any hairstyle that he chooses. The EEOC was really helpful in advancing this conversation about hair-based race discrimination. And it really helpful in advancing the conversation. It really brought us to these historic moments when it filed catastrophe management, the catastrophe management case in 2014. So the 11th Circuit issued an opinion in catastrophe management that found that such discrimination was not race discrimination. And I'm curious to know, when you're looking back at that opinion, what did you think the court missed or misunderstood about why bans on Black hairstyles like braids, locks, twists are race discrimination? What did they miss that our state legislatures seem to be getting? And if the Federal Crown Act does not pass, or in the period before the Federal Crown Act ultimately passes, do you believe that these legislative movements will have an impact on future Black hairstyle grooming code cases before federal courts now?
Well, thank you for the question, and good morning. It is a great honor to join all of you. And I, Angela, first I want to say I very much appreciate your scholarship in this area. Before I respond, I just want to say very briefly how incredibly saddened I am that Justice Ginsburg is not here with us today. And she, of course, has been instrumental and inspirational in the area of sex discrimination and will be truly missed. I do think that the legislation you're talking about, which protects against discrimination based on African-American hairstyles, be it locks, braids, or other natural styles, is raising awareness of these issues. And in that sense, it will lead to more, have an impact on the courts, because I think we're going to start to see more cases. I think, and I appreciate your saying how helpful we were in advancing this issue when, by the way, for those who have not read the case, we did not prevail. But the new legislation would not be necessary, I think, if Title VII were examined and applied in the way that it was intended. I think there's a disconnect between African American women's experience and workplace rules prohibiting Black hairstyles and how this issue is presented in court. I do not necessarily think that the CMS case that we put on is necessarily the model, but I think it is instructive to all of us because this is one of the many areas where the way Title VII jurisprudence has developed fails to fully protect women of color. So for a lot of courts, for a lot of people, this seems like maybe a rare and niche issue about dress codes. I want to reframe a little bit because for Black women, this issue arises daily of whether their employment requires them to physically alter a part of their bodies, specifically their hair, to conform to white norms. So throughout US history and now, the stigmatization of African Americans' physical features has been part of efforts to dehumanize Black persons. And it was used to justify slavery and other discrimination, abuse, and physical violence. Every physical feature, skin color, body type, facial features, and hair texture was stereotyped, mocked, made the subject of minstrel shows, you name it. And this practice, of course, of demonizing particular physical features to justify discrimination is not particular just to African Americans. It's anyone who's considered other. Persons of color of all races have been judged based on physical features that differ from what's considered a Western European norm, as have many Jewish Americans, Italian Americans, and persons of other ethnicities. Interestingly, the way this has developed, the most obvious of the physical characteristics, fortunately, color of skin, is already in the statute. But as to the others, courts seem to look to whether discrimination based on the particular physical feature associated with a particular racial group can be called a so-called immutable characteristic. And here's the thing, most of the stigmatized physical features associated with race or ethnicity are harder to change than hair texture. So as a result, for purposes of anti-discrimination law, hair was not necessarily considered an immutable characteristic. So while I expect we would all quickly identify as discriminatory a rule requiring that workers undergo plastic surgery to match the size and shape of their nose, their eyes, or their mouth to a Eurocentric view of what appeals to customers. Rules requiring a compliance with Eurocentric definitions of professional hairstyle have often been deemed race neutral. So that brings us to the CMS case and what I think I certainly have learned from it as we look at how to close that disconnect, if you will, so that the law fully affects, and that's, you know, from our perspective at EEOC. The case, quite briefly, involves an African-American woman who applied for a job, was granted the job, as she wore her hair in short locks and was told that, and this is the HR manager speaking, and I'm gonna quote here, they couldn't hire her with the dreadlocks because they tend to get messy. Ms. Jones was given the choice of cutting her hair or not taking the job. So she did not take the job. We filed suit on her behalf. And at court, we took the position that this was an intentional discrimination case. We could have obviously, I think, and probably perhaps more successfully, argued it as a disparate impact case, that the locks rule, or, you know, the professional rule, and by the way, this was a rule about professional hair. There was nothing about dreadlocks per se in the policy. So what was interesting about the case is that the court struggled palpably with the idea of defining what is race, or what was race in 1964. And that is a large part of the opinion, and relatively little about racial stereotyping. And I was very interested to hear the last panel's discussion of the anti-subordination view of race discrimination as potentially being less well developed in the area of race than it is in sex. This, I think, was, you know, the upshot of it was that the court found that discrimination on the basis of Black hair texture and immutable characteristic is prohibited by Title VII, while adverse action on the basis of Black hairstyle, a mutable choice is not. So in that case, the court did recognize that hair texture is there, but did not understand what it meant to prohibit, in this case, have a policy that defined as not professional. Pretty much, it seemed, if you look at particularly the examples that are cited in the case. So braids are not professional. There's a helpful footnote on that. Locks, we know, are not professional, and question mark as to afros. But if you put it all together, what African-American women are left with are cutting their hair very short, similar to a man, or having their hair straightened artificially in ways that are very damaging to the hair, but more similar to white women. There is not room for a professional, regardless of how well and neat the particular hairstyle is, for a professional African-American woman's hairstyle that does not fit within those rubrics. And I think the failure to recognize what that means, because, and the sort of this impact of reasoning from the body in this way, I think took away from the court's ability to step back and say, well, what does this mean in terms of stereotypes? Why is it that everyone assumes that it's unprofessional to have locks? What is that about? That was not fully addressed. And I think that this question of what it means to racially stereotype in that way really needs to come to be developed more. I think the case is quite interesting in that way. So I'm going to stop there, but I do think that it's important. This is just one area, one example, but it's important to realize what it means when we sort of, take out certain perspectives from the legal applications.
Very much agree. No, yeah, it really stresses the importance of education and really, the importance of education and the importance of not defining certain groups as the norm. Or that's great. It's fantastic. So I'm speaking of grooming codes. I want to move on to Alfonso David. The U.S. Supreme Court issued a historic opinion in Bostock versus Clayton County, holding that Title VII also prohibits employers from discriminating against employees because of sexuality or gender identity, because such discrimination is discrimination because of sex. And in the grooming codes area, courts have generally recognized an exception to Title VII's prohibition of sex discrimination for gendered grooming codes. And they say that those are fine so long as they don't impose an unequal burden on one sex more than the other, and talking about men or women. So how do you think Bostik might shift our analysis in grooming code cases?
Well, thank you. Thank you for that question. And my pleasure to join all of you this morning. I also want to extend my condolences to the Ginsburg family and to all of us who are still mourning. So in response to your question, one of the three cases consolidated in the court's decision in Bostock was a case called RG versus GR Harris Funeral Homes. And in that case, gender dress codes were central to the question that was posed before the court. Amy Stevens, the plaintiff in that case, was fired by her employer after she told her boss that she was transitioning to female, and when she returned to work, she intended to comply with the employer's dress code for women by wearing a skirt and a suit jacket. Now, her employer said in response that they had a concern that her dress would distract their customers from the grieving process. Now, the court decision in Bostock clearly makes it impermissible for an employer to restrict a transgender woman from wearing women's clothing, but the court also expressly says that it was not deciding the question of gender dress codes more broadly. Amy was not challenging the gender nature of the dress code in that case. She was demanding to be seen for the woman that she was. And all of you may know, unfortunately, that we lost Amy earlier this year before the Supreme Court decision was actually issued. Now, to the core issue that you just raised, PricewaterhouseCoopers should have laid to rest the question of gender dress codes. Ann Hopkins in the Pricewaterhouse case was told to walk more femininely, talk more femininely, wear makeup, have her hair styled, wear jewelry. And in that case, the Supreme Court found that that was contributed to illegal sex stereotyping. It's troubling that some district courts and appellate courts have not consistently adhered to that concept. In 2002, as an example, the Ninth Circuit held that gender dress codes and grooming codes did not violate Title VII. It's a case called Jesperson versus Harris. It's litigated by a very good friend of mine at Lambda Legal. That court was unable to see the requirement that a female bartender wearing makeup, teasing her hair would place a unique burden on women. On the other hand, much has changed since Jesperson. That was 18 years ago. And LGBTQ people have contributed quite significantly to challenging norms around gender. So the Bostock case really does not directly address this issue, and I believe that PricewaterhouseCoopers does. And unfortunately, courts have not consistently interpreted PricewaterhouseCoopers in the way that it should have.
Oh, Betsy, we can't, I think you're muted still.
If I could just add a comment, I read 40 pages of the majority decision in Bostik. I'm really not sure why there needed to be such a long opinion, because at the end of the day, the court said, you know, if you take action based on someone's gender, in other words, you do something to a male that you, or to the female, that you would not have done, action that you would not have taken if the person was of the opposite sex, it's unlawful. I mean, it seems like that's just was the theme. And I would think that that would support the, you know, and maybe there were precedents before this, but that would support, you know, opposition to grooming codes, because if the grooming code says that women have to wear skirts, and you fire a woman for wearing pants, that would seem to me to be per se a violation of Bostik, because you would never have fired the man for that reason. But that's just, you know, so I think it should help in those arguments.
I entirely concur with your opinion. I think that it should. But I think what's interesting here is that we're still having this debate when I think that PricewaterhouseCoopers actually determined this question. You know, PricewaterhouseCoopers clearly decided this question, and yet we're still talking about, you know, gender codes and dress codes and whether or not it violates Title VII, and that question keeps on coming up. So I agree with you. I think Bostock once again says, you know, doesn't directly say it, but it certainly, I think within the opinion, the construct would support the principle that Title VII, that dress codes, certainly requiring someone to comply with certain dress codes, and it's not consistent with their gender, would violate sex stereotyping rules.
I guess one of the questions is, do we think that will attorneys start advising their clients differently based upon Bostock about grooming codes, for example, or even related? What other types of cases do we think that we think might come out of Bostock? What are some of the other kinds of cases? This is for everyone that we think might come out of what new litigation might we see as a result?
I mean, I hope that attorneys are sort of looking holistically about where it is that they put out gender-specific rules, and possibly unnecessarily. So that would be a first step that I think employers are hopefully taking. I also think, you know, some of the litigation that we expect to see is going to be around squarely does Bostock's application in the workplace context under Title VII extend to all the other places where sex discrimination has already been prohibited in education and healthcare under state laws? And I think that, you know, there's already some litigation around the healthcare rights rule, the Section 1557 of the Affordable Care Act. And I think where we're gonna have likely a lot of litigation is the issue that the court absolutely didn't address, and on purpose didn't address, is the issue around where the religious Freedom Restoration Act intersects with our non-discrimination protections. And I will say it'll be around religion and who can bring these cases at all, but also whether it is religion, but also moral objections. And I expect to see a lot of creative sort of theorizing around that in the workplace front, but also in the education and healthcare fronts as well.
Yes, I would agree with that. And I also have to just say that since we were talking about Harris Funeral Homes earlier, which was a case that EEOC litigated in the Sixth Circuit, we had also seen in that case and were successful in defeating a claim that under the Religious Freedom Restoration Act, the EEOC, and for that matter, any federal government enforcement agency, may not bring or may not enforce Title VII against a religious employer. And here, this was not a religious organization, it was a private funeral home, privately owned funeral home, solely because of the Religious Freedom Restoration Act and the particular obligations it places on the federal government. So I don't know, but I have a sense that we'll continue to see that. I, of course, am very pleased that the court adopted some of the arguments that the EEOC had been making for some time in Bostock. And I, am grateful to all of our litigators who worked on the Second Circuit en banc brief and else in all of our other cases on those issues. I think there will be basically 4 areas, and I also think there'll be an increase. Even in states like New York that have jurisdictions with state law protections already, I think that we will be seeing more of these cases because employees will be more comfortable bringing them even in the federal courts at where it's appropriate. And we, in fact, settled our first sexual orientation case post-Bostock just last month in New York, and I anticipate we'll be seeing more. We have each year, even before Bostock, EEOC has received every year a steady increase in the number of LGBTQ worker claims. And so even before this, I don't have any reason to think that trend would not continue. And I think Bostock is going to accelerate it some. The 4 areas where I see are, of course, the religious claims, the ministerial exemption, along with the Religious Freedom Restoration Act claims. And there's been some interesting developments in the Seventh Circuit around whether or not the ministerial exemption actually applies with respect to claims that are harassment claims in employment. The Seventh Circuit said those are different, that the ministerial exemption really talks about who you can hire and fire. So I think there'll be a lot of litigation about that. I think, of course, privacy issues, frankly, around bathroom usage, just based on what we're seeing in our federal sector opinions and also in the charges coming in, grooming rules, which we talked about, and unfortunately, harassment. Those are the fact patterns. So I'll stop there, but I think we're going to see a lot more action in this area.
In response to that question, 2 things I think. We're already seeing the power of the Bostock decision. The 11th Circuit and the 4th Circuit both recently determined that Title IX of the Education Act prohibits discrimination against transgender students. And here in New York, the Second Circuit in Walker versus Azar, which is an HRC case, we're working on this case with Baker Hostetler. We challenged the Trump administration's determination under 1557, which is the Affordable Care Act, seeking to undermine healthcare non-discrimination protections for LGBTQ people. And last month, Judge Block in the Eastern District of New York enjoined enforcement of the rule a day before the rule was set to go into effect. So that's a real real world implication of Bostock that we're seeing now. And I also agree with Fatima that we're going to see Bostock implicated in all areas of federal law where it prohibits discrimination on the basis of sex. So the Fair Housing Act, the Equal Credit Act, the Education Act, the Jury Service and Selection Act, I think we'll be seeing Bostock implicated in those areas as well.
Thank you very much. It was great. Let's turn a little bit and look at COVID-19 So COVID-19 has had a disproportionate impact on certain groups, and it's certainly disproportionately affected individuals from historically marginalized communities, and in particular women of color. And because employees are vulnerable to losing their jobs, particularly in a time of economic uncertainty, they're also probably less likely to report sexual harassment or any discrimination out of fear that they might lose their very livelihood. Additionally, as more employers find themselves operating in a virtual setting, they might be engaged in fewer harassment prevention efforts. They might be engaged in less oversight, right? And so that's adding less protection for employees in the workplace. And in what ways do you anticipate that the pandemic might be affecting the legal landscape for sexual harassment plaintiffs in particular, or other plaintiffs? And do you foresee a shift in the number of sexual harassment claims that will be filed in the aftermath of the pandemic? I'm asking Fatima first. Fatima.
Sure. It might be helpful for me to add a little bit of just short data to contextualize this a little bit. The first thing is that, women are the majority of essential workers, but they also in this period, in part because of job segregation, have lost a majority of jobs. And so we've had this situation where you have a lot of people who are working sort of on front lines in healthcare, but also in grocery stores as care providers and other fields that are really dominated by women, and working sometimes in conditions where there are meaningful safety concerns broadly, and a sense of urgency. And for Black women, about 1 in 3 Black women who are employed right now work as essential workers. So I just, some of that data, I think it helps ground us a little bit. And one of the things that we know about workplace harassment is that not only do you often get an uptick in those types of claims in times of economic distress, you also get always a pretty close tracking of harassment and retaliation together. And some of that retaliation can get both bound up in work conditions, the sorts of getting a worse assignment, not getting the PPE, getting, making your experience even more less safe. And some of it can get bound up into the mass layoffs that are happening right now. And so one of the things that I think we will start to see in the litigation is a more meaningful question around this period of what actually constitutes harassment, what types of conduct in this new reality constitutes harassment, and what constitutes retaliation in this new world. And then I just will add, these are the sorts of times where work becomes more precarious, and you have the real potential for more and more people to get work, but have that work be classified as not employees, coming on as temporary contractors. And so I think there will be increased litigation over who is actually an employee in this time as entire sectors are rebuilding and reimagining themselves.
I'm sorry. I'll let Betsy.
Good. If you want, I was going to jump in on a sort of employer perspective on this issue, and I think there are a lot of concerns. For one thing, we encourage employers to conduct training of their employees on a regular basis and in fact, it's mandated in New York on an online basis at least, but we encourage employers and many have adopted a practice of having training, especially for managers. And one of the I'll get to the bystander issue. And so that can't really go on very easily during COVID when everybody is, flown to the wind. Another aspect of it is that more recently we try to focus managers on their responsibilities as witnesses, if you will, or bystanders, and to train them to be proactive, not just what to do if somebody complains to them, but to take some steps when they see behavior. Well, nobody is seeing, you know, whatever harassing behavior might be going on now, but we do know that the use of social media can be a method for harassment, or a tool that people who have that, you know, sort of bent would use, and it's very difficult to monitor that. And, you know, so I think it is a real concern for employers as to how they can take steps that they would normally take in the workplace because certain conduct would be observed, but nobody's observing it. And as someone said, I guess, Fatima, you know, people are reluctant to complain. Another aspect that we've noticed in our practice is that we're conducting investigations of behavior reported, but we can't do it in person, and that's not ideal. I mean, when you're conducting an investigation, and it's especially if it's a he said, she said situation, we're doing it on Zoom like this. So that's just another factor that you know, a way in which COVID-19 has impacted the practice.
I would agree with that. Our investigators are in the same boat, and you know, unfortunately, the more severe it is, you know, the less likely you want to report in a virtual context. You want to look someone in the eye and feel comfortable if you're going to talk about the fact that you were raped at work, right? So that's a challenge. I think it's a challenge for employers. It's a challenge for us. And it also, one of the things that I found, and I've actually had, you know, I do a lot of these webinars and had employers say to me that they've been, you know, it has changed the ways in which you can report. So that, and that they, not all of them who raise this have actually gotten around to fully explaining that process to their employees. So I think there may be some claims around that during this, through no one's fault. I don't think it's intentional, but during this period, folks who might have been trained on how to report in a particular way to their employer are now, you know, realizing, well, they can't walk down to that office. They can't do the certain things. And so they're sort of wondering, well, which link am I supposed to click to report? Because it's, frankly, it's in flux a little bit. Not everyone, but there are a few employers who, you know, have shared that with me in the context of this, you know, very anecdotally, of course, in this time, that they are, you know, realizing that their reporting structures have changed and they haven't told the workforce what the changes are, not because they have any bad intent, but because everything is in flux right now. So I do think that there may be arguments around that that will start to creep in as time goes by. I think that, you know, I just like to just flag that we also are seeing, you know, I had hoped that maybe, oh, it's hard to do in-person harassment, so maybe this will go down. We'll see. I don't think that that has changed, unfortunately. And a lot of the workplaces, you know, there are still a lot of folks who are going in, and there are fewer witnesses. There are fewer people who can intervene. There are fewer people who can be reported to. And so, unfortunately, so hopefully that'll change, but we don't see a difference. We had always been seeing for, you know, a good number of years now, at least 1/3 of our charged caseload are harassment cases. And that's on all bases, not just sex. But we also saw in the year after Me Too went viral, almost a 14% increase, 13.6% increase in harassment charges during that time. And it has been, frankly, a very difficult sort of period working through that. And I am hopeful, though, that we'll still be able to make headway notwithstanding that. I think the biggest change, though, Angela, is what you referred to at the beginning, which is that people are very concerned about retaliation. They're very concerned about losing their jobs. Fatima mentioned this as well. And so what does that mean in this context when there are layoffs and financial uncertainty to be raising these kinds of claims? when we already know that very few people who experience this harassment actually report it. So that has been what we're struggling with in terms of our outreach, et cetera. And what I think we're going to start seeing in those cases that do go to court as sort of issues around, you know, why didn't you report? Did you not know what was going on? And there were fewer people there. I think all of those kinds of arguments may come into the actual litigation as well.
So I want to follow up on a couple of questions I think you raised. If you have suggestions for how do you think those things should be analyzed in particular cases. So number one, the issue about employers who haven't, who, you know, I mean, and many employers made a change to sort of a different environment rather rapidly. And so, and not updating structures for reporting harassment, right? And so how do we apply the fair evidence defense in such circumstances, those kinds of circumstances? I'm just curious to know, and Fatima, you mentioned things about, you know, ways in which you think what constitutes harassment, what constitutes retaliation might change basically in this new world. And what are the ways in which you think the analysis should change, you know, given the new world, right?
Yeah, I mean, listen, Farragher and Ellis don't have I was too busy part of the defense to do it. Like, part of the reason you have that defense is that you want your employees to come to the employer and let them know about it so that there's an opportunity for the employer to correct quickly. And so that, you know, that has been the sort of notion that employers have understood for the last couple of decades. And so there probably are some decisions. An employer that says, look, I can't prioritize addressing discrimination and harassment in my workplace, so I'm not gonna tell people how to report in this new climate, in this new context. I would hope that a court would not look favorably on that decision because the truth is, at the heart of it is you still have someone who is working in conditions that may be unsafe, and that individual may be representative of other individuals who are working in conditions that are unsafe. So what I would say is that I don't advise employers generally, and so Betsy might be have a different approach, but if I would hope that the advice that's going to employers right now is that actually in these sorts of conditions, the risk can be higher. People are under stress. Employees may be engaging sometimes in conduct that is totally inappropriate. You have an obligation to actually make it front and center. And I also think, and this is maybe a hope and dream, that if this period demonstrates that employers are unwilling to adapt because of a pandemic, I don't think that's the case, but if it does, I think it really questions that sort of bargain made in Farragher and Ellis in powerful ways. And then just the last thing that I would say is, what this period has really brought back to me was the court's decision in Vance, where it, really construed pretty narrowly the idea of sort of who was a supervisor and had the authority. And I have to say, in one of the things that, Charlotte and Alfonso raised about how many people are actually on these sites, that people have been, there's been a lot of culling back. And so the usual schemes of who is on site and who is available, it might have shifted. And I think that does, in my view, I think you may see people sort of going back and questioning that piece again. The people who have the ability to day-to-day dramatically change the experience of workers on the job, and their supervisor may be nowhere to be found or changing or unknown in this period. The point is, people have to have a place to go. And if the employer is putting individuals in place that are effectively running spaces, that the employers should have some responsibility to ensure that those people in charge are not furthering harassment.
Well, I think in some ways, the working remotely reduces opportunities to engage in bad behavior towards people, right? So of a certain
right.
kind.
So I'm thinking mostly of the essential worker, you know, like 1 in 3 Black women are
right, people who are actually there, yeah. But hopefully, you know, for most organizations, there are people identified as the place to go for help, and that, you know, those people are reachable by email and phone, and hopefully those processes will continue to work well.
Focus on sexual harassment, but really turn to a sort of a new, different way of thinking about and bringing sexual harassment suits. Derivative actions are another alternative way for shareholders to challenge sexual harassment in the workplace. And these shareholder suits typically assert that director defendants had knowledge of alleged sexual misconduct, chose to cover it up for nefarious reasons, and that financial and reputational harm befell the company as a result, right? And in these actions, the shareholder brings the suit on behalf of the company, and any resulting award is granted directly to the company as opposed to the individual shareholders. Defendants have typically challenged these class actions by arguing that the plaintiffs don't meet the pleading requirements under the Private Securities Litigation Reform Act and the Federal Rules of Civil Procedure. So, for example, in Lopez versus CT Partner Executive Search, the Second Circuit found that the defendant's statements regarding the company culture were immaterial, quote, immaterial puffery, because the statements were really just far too general. In a district court case, the company's code of conduct was general, essentially didn't give rise to any kind of concern. So how do you think these rulings, this is a question for Betsy, affect the way in which employers fashion their company culture or their code of conduct? In any way, does it sort of incentivize companies to make only generalized, sort of open-ended or aspirational statements as opposed to sort of more particularized statements that might explicitly decry sexual harassment or other forms of discrimination? And should courts even be concerned with these kinds of questions?
So thank you, Angela. And I wanted to include this subject or process because it's new. And so we included it in the outline. It's new, and it's something that I think we will see a lot more of, in particularly within the Second Circuit. The 3 securities law cases were all cases that were filed in the Southern District. And I think being, you know, mindful of a whole new plaintiff's bar in the securities world, and the Me Too and public disclosure of bad behavior, let's call it, by, you know, people whose names get in the paper, I think has all led to, you know, lawyers coming up with a new avenue to challenge corporate action, or more importantly, inaction. And I don't think there'll be a lot of cases, but I think that they will continue. And I don't think they'll have the negative impact, although that part of your question I thought was very interesting, Angela, about whether, you know, if under the securities laws, you're better off having vague comments. You know, is that going to encourage companies to water down their code of conduct? I don't think that's the case because, and I'm no expert on white collar, but a lot of code of conduct requirements arose out of, you know, the Department of Justice taking that into account if a company does something bad. And the people who draft those are, you know, I think very rigid. They don't change the code of conduct very often. And I think what these securities cases will focus on more is, did the company know about a pattern of behavior, you know, or did the board of directors know about a pattern of behavior of the CEO or some other senior executive and didn't do anything about it? And including, you didn't disclose it to shareholders. Now, Is that material? I mean, I'm not a securities lawyer, but I think that that's the type of argument that's being made. And the more that, the media, digs up that kind of information about senior executives, I think the more vulnerable companies will be to these kinds of lawsuits that are, totally separate and apart from Title VII type cases. So that's just my thinking.
The effects of, I think, of a greater visibility for sexual harassment that was brought on, of course, by a variety of things, but Me Too was the latest thing. The reemergence of Me Too was the latest thing. A return back to the Farragut-Ellerth defense and particular. So one way in which sexual harassment plaintiffs are seeking to narrow the defense is by arguing that the harassing supervisor holds a sufficiently high authority position in the business, right? So in Townsend versus Benjamin Enterprises, the Second Circuit held that the Farragut-Ellerth defense is unavailable when the alleged harasser is the employer's proxy or alter ego because they hold a sufficiently high position within the hierarchy of the organization. And so how does this, which is really great, but how does this proxy alter ego theory unintentionally expand remedies for perhaps higher socioeconomic status sexual harassment plaintiffs while failing to provide expanded remedies for lower socioeconomic status sexual harassment plaintiffs, right? So a supervisee of what the court would call an apex employee is in all likelihood more highly positioned within the hierarchy of an organization. And so that person, those employees are able to avail themselves of this proxy alter ego theory and to limit the Farragut-Ellerth defense. Meanwhile, lower level employees who still experience sexual harassment and maybe even more vulnerable, but experience it from a non-apex supervisor are unable to avail themselves of the proxy alter ego theory. And so they would be unable to bar their employers from asserting the affirmative defense. So in what ways can sexual harassment law further develop so that these expanded remedies are really sort of able to be enjoyed equitably by all plaintiffs? And this is a question for everyone, but I imagine Fatima would be someone who would be particularly interested, and Charlotte as well.
Yeah, I have a couple of thoughts that aren't super clear, but I will offer them anyway. The first is that I think you have to think about different types of entities. One of the things that Weinstein has obviously, and the Weinstein companies have obviously become sort of the example, in part because Me Too went viral after those stories were disclosed. And what you saw there was sort of a cross-level type of complaints from assistants who had who were paid the least in the organizations to people who, at least on paper, seem to have a lot of power within the organizations, making similar types of complaints. But I hear your point, but I think it would probably depend on the organization. I actually think there is something additional there that I think is important that has come out, and that is that if you're talking about conduct that either happens from sort of the top of the organization, but it also sends a clear message to lots of other people in the organization around what is and isn't tolerated. And sometimes that message flows all the way up to the board. So one of the things that I think organizations are grappling with now is sort of what is the responsibility for the board and what is the responsibility for leadership, not only around their own conduct, but the very clear message that they send to people who have the ability to shape the experiences of their workers. And so I think so much of this is still unfolding, but it is my hope that the answer to that question in part involves boards understanding that they have a different level of responsibility, especially when there is something that amounts to leadership involved, not just because of the leader's individual conduct, but because of the additional messages that may be sent systematically across an organization.
I would agree with that. I want to say that I want to push back a little bit on the assumption, because one of the things that we have seen over and over again is that harassment is really about disparities in power. So often it is not that unusual, actually, for someone who is at the very top of the company to be harassing someone with very little power, a law partner who is harassing a secretary or receptionist or a junior associate. That power disparity, if they are in, working in the same workplace, actually can feed the likelihood that someone thinks, frankly, they're going to get away with this. And so while it, particularly those sexualized conduct cases seem to be about sex, they're really about power disparity. So I think, what we've found is that it's not actually so unusual for someone who has very little power to be, the target of this from someone quite high up. So but nonetheless, it does happen. I think that the difference is, I know that some courts, we have a movement afoot, if you will, at the state level to do away with the Farragher-Eller defense, which, it says that if the employer can show it took reasonable care to prevent and promptly correct harassment, and that the employee unreasonably failed to take advantage of any preventive or corrective opportunities that the employer offered to avoid harm, then there's an affirmative defense available to the employer. But I actually think that in the rubric of those, part of what needs to happen is sort of a greater understanding of the reasons why, just as factually, or maybe it's just digging deeper, the reasons why someone might not report. And I think that is an area, I actually don't know whether or not it's likely that there'll be a move away from Farragher-Eller in the federal context. But I think it works as long as the underlying spirit is taken seriously by courts and juries. And so I am less worried about who gets the, is it unfair that you can only raise the alter ego with respect to someone who is sufficiently high up. In some ways, frankly, for the entire workplace, that's appropriate because you are sending a signal about what's allowed, and that can have, we have found time and again, cascading consequences for other folks engaging in the same kinds of behavior. So I think that, one of the things that I've seen is that some courts after Me Too went viral, and certainly juries have been moving in that direction. And that's one of the things that I think that we at EEOC will probably be continuing to develop and to explain to juries why that is, why people may not report, and really sort of looking behind. Yes, there's many employers who, I think most employers have wakened up to the need to do the right thing, but sometimes you find they've got a great policy, it's in a drawer, no one knows about it, right? So looking behind and really taking seriously what's meant by those two prongs, I think, is an area that I anticipate and certainly I think should be further developed going forward.
If I could just briefly,
go ahead.
Briefly comment on the alter ego theory. In addition to, I think, what Charlotte and Fatima are saying, which I entirely co-sign on, as we think about how this theory applies in litigation, I also think one concrete way that sexual harassment law can be developed is by remedial legislation from Congress that clearly defines and sets parameters for the defenses that are available to employees. I think Fatima alluded to this earlier, that we have to always be mindful that the disproportionate number of victims of sexual harassment occur in certain industries, and they occur generally for women who are living at the lower end of the socioeconomic spectrum. 40% of the women in fast food industries have reported being confronted with unwanted sexual behavior. And so, we have to think about, in addition to using litigation to refine these concepts, maybe legislation is another tool. Another potential tool is collective bargaining. Doesn't apply in every single workspace, of course, and it may be a little unorthodox, but that may be a way to actually develop sexual harassment law in a way that's favorable to plaintiffs.
And I just wanted to add, there was a reference to legislation that in New York, since many of the folks in the audience are in New York, the change started with actually a court decision holding that the New York City human rights law, that there was no Farragher-Ellis defense available. Essentially, it was the holding of a case involving the new school. But then the New York State legislature amended the state human rights law to, again, eliminate the Farragher-Ellis defense. So I don't know to what extent that's happening around the country, but that's another approach that's being taken.
Could I just add one more thought on this? That since we're talking about plaintiffs of lower socioeconomic status, I think what I have noticed, and I've want to sort of look at this in a more thoroughgoing way and see what we at the commission should be doing about it, that lower socioeconomic status individuals tend to get less damages for their harassment. There have been many instances where it appears that if someone has suffered egregious harassment, there is, sort of a subtext of, well, how much do they make, and what are their damages relative to their salary? It's unspoken. But if you look at some of the cases, for instance, and there are a number of cases where very young men of color are subjected to sexual touching, genitalia being grabbed in the workplace, both same-sex and not, where oftentimes it's a construction site or it's working class jobs, and that same behavior targeted at a upper class woman in the workplace, in a different workplace, would be, I think, the dollar amounts of the damages are way disproportionate to that. And I think that there's something to be said about understanding whether that actually is what justice looks like. And so I think that's something that damages, not just the relief stage, but then what happens to make whole. And look, there are a lot of very egregious things that, as a cultural matter, people of color and men of color particularly are going to testify about differently, and perhaps in ways that may not fit what stereotypically the damage testimony of the victim of sexual harassment looks like, because oftentimes the media portrays that as a woman who is either a white woman, fairly young, in a different kind of workplace, and that's what people are used to seeing. So I just want to flag that there, even in the cases, frankly, that we settle, right? That I'm not necessarily talking about judges. I'm talking about our own settlements as well. There is a vast disconnect, frankly.
That's a really important point. I'm glad you mentioned that.
That sounds like something worth studying.
Yeah.
Comparison.
In progress. Thank you. I agree.
We only have we only have 2 minutes before 11:45, and we wanted to open it up for questions at 11:45. And so I want to just give panelists an opportunity, if there's something, we didn't get through our questions, but give panelists an opportunity if there's something that you really feel compelled, anything you wanted to talk about, or any questions or issues you wanted to raise before we move to Q&A. I'd love to have you do that. So.
Well, there's just one more thing that I wanted to name, and that the state laws are changing pretty rapidly. And so I think some of the questions around what are the interventions that could actually make a meaningful difference, we might see and have more data on that soon, because we have had 3 states in the last couple of years limit employers from requiring employees to sign NDAs. We've had 5 states in a number of cities change who is covered under the law and expand to expressly include contractors and interns and grad students. We've had states, at least 5, I think, expand their statute of limitations periods, and a lot of states, over 10, shift the prevention obligations of the employers. And so, you know, it's hard to have meaningful data of the, you know, what the end result will be of this shifting landscape. And anytime you have such a shift, it puts a lot of pressure at the federal level to say, okay, obviously our baseline has shifted, and so we need a new additional baseline. And that's a lot of the focus of my organization.
Anyone else? Okay, so I'll pose the first question that I see from and it's really a question, it goes back to COVID-19. Someone said that they're finding, sadly, that a lot of clients, employers are actually using COVID-19's broad acceptance of certain actions and thinking as a valid excuse to let go employees who they previously wanted to let go, but didn't let go. And they're hearing this quite a bit. And they're wondering, is this also a common theme that you're hearing, or is this a common theme with others?
You know, I am for sure worried about this as a phenomenon. You had such dramatic and historic rates of unemployment. And there's some sectors that totally had to shut down entirely for a period, and others that made decisions around laying people off in advance. It is hard to actually ferret out what piece of this is actually due to economic considerations or basically a plus. There were economic considerations, plus they wanted to get rid of this person for a reason that is prohibited. And I imagine that there will be some litigation over that in some instances, and including who is hired back. You know, there are some organizations that did temporary closures and then had to make decisions about who came back, and not everyone could come back. And so I suspect that we will see this. That's actually true, though. In other times of economic distress, you did have some employers try to hide what amounts to forms of discrimination under the guise of broader layoffs.
Yeah, this is Alfonso. I mean, thinking about, and we've seen this before in the 2008 recession, we saw this where, you know, employers constantly have to think about, is it a furlough or is it a RIF? And depending on which bucket they end up going with, it has significant collateral consequences. What we're concerned about, of course, is making sure that employers are not using the layoffs as a pretext for really engaging in unlawful discrimination, firing transgender employees, firing LGBTQ employees. But to Fatima's point, I don't think it's so difficult to know in this context. I think within the furlough bucket, where some employers are picking, well, we will furlough you for a few months and then make a determination as to who will we rehire, you have a little bit of insight when the rehiring process starts as to whether or not there was an attempt to use the furloughs as a proxy. But it's a very difficult issue, I think, to ferret out.
We have another question about the role of the federal courts, and someone's really wondering, is the role of the federal courts in protecting workplace equality, is it actually diminishing due to the multitude of state laws that are granting greater protections than Title VII?
I mean, I still think a lot of people would rather be in federal court. And so, I mean, that's why I raised that part of our task is looking at building support for the Be Heard Act. I also think one of the things that I imagine companies would say that is difficult for them is that, you know, in New York and California, you have one set of rules, but in Illinois, you have another. And as the bar comes up, then you hopefully will have employers setting better approaches across their organizations, no matter the state, but that also will take some time.
Right, I would agree with that. I don't think that the role of the federal courts is diminishing per se, particularly because while we do have a number of state petri dishes, they're going in different directions, frankly. Depending on what state you're in. And I find that just from an overarching, you know, as one country, that's troubling in terms of, you know, what the federal laws are intended to do is to give a certain level of protection no matter where you happen to live. But I also think that it's, you know, at least for me, it's not lost that a lot of these states, with the exception of maybe California and New York, a lot of the states that have the highest minority populations are the states where you're not seeing increased protections. And so I think that, you know, no, the federal courts will continue to be enormously important in this area. And I think that probably the effect of the state court laws and changes will be that these arguments will start to creep in to what people bring, what litigators bring to you will sort of be informed by what their last case, which may have been in state court, or what they've just read, which may have been in state court, will be doing. So there will be that cross-pollination, but the federal court's role, I think, will not be diminished.
Just one additional context for folks to appreciate. In 29 states in this country, there are no comprehensive protections for LGBTQ people. So when we think about intersectionality, which is something that we didn't have enough time to get into, but when you think about intersectionality, I'm a Black man and I'm also a gay man. If I face discrimination in the workplace, in some cases, the discrimination may be intertwined. And as you think about whether or not any protections or the venue that I ultimately choose will be in some instances driven by whether or not I think I can get those protections in federal court versus state court. We still don't have the Equality Act, which would provide comprehensive protections for LGBTQ people. But we do have Bostock, which does provide protections in employment and by extension, as we said before, other federal statutes. So I agree that the federal courts are going to continue to be important. And in many cases, we still have to push to have protections in state courts or in states around the country.
Betsy, did you want to add anything to that at all, the question?
No, I just wanted to say, I agree that I think federal courts are still the place that many plaintiffs want to be for a variety of reasons. But what's happening in a state like New York is that the emphasis and the closer you get to trial is on remedies available under state and city law, less than what's available because it's the remedies are greater and the defenses may be lower. So you end up in federal court, but litigating a case in the end may be under state and city law often.
We have another question. Says it's a follow-up to this. The last question, what about the lack of diversity on the federal bench, including the lack of professional diversity? Shouldn't there be a push for more diversity on the bench? And it seems like we have some great candidates right here on this panel for
I lament. Yes.
What else? What else can you say except yes?
Yes, I mean, there are many organizations, including mine and Fatima's and the Leadership Conference and others, that have been really advocating to make sure that we have diversity on the bench. And it's not just, you know, sexual orientation, gender identity, gender, race, ethnicity. It's really also making sure that we have a diversity of perspectives. That in many cases the bench has been filled with a certain type of person. And it's really important as we think about making sure that the bench is reflecting the populace, that we have more diverse people on the bench. So wholeheartedly agree.
Yeah, I would second or third that, I guess, that there's some real, I guess I should start by saying, I think that we always get to the best results when there's a diversity of views, there's a synergy in that. And I think it's important, given the enormous power that courts wield, for there to be an understanding that that the courts reflects America, and particularly in those states where there are large, you know, if you look at some of the circuits where the largest minority populations are in some of the southern states, you know, it's particularly salient, I think, in some of those areas.
Angela, I think you're on mute.
Thank you. So I said one more quick question, and then we'll just give everybody 30 seconds to close out. And so, so I'm going to follow up. On one of the state law question. Do the disparities among states' protections for workers endanger nationwide equal justice under the law? And how do you think this concern can be addressed?
I should just say that there always has been a disparity among state protections for workers. There are some states that don't have an equivalent to Title VII of the Civil Rights Act. So the only protections in that state are the ones that flow from the Civil Rights Act. And so I guess I would shift this question a little bit and just say one of the things that we learned from activity and movement in the states is whether or not you need to shift the federal bar. And as more and more states have pretty quickly, more than 15 states since Me Too went viral have made changes to their laws, have quickly sort of tried to assess what are the types of interventions that might be important to get at harassment and discrimination in this time. I actually think that is a signal to what needs to happen overall. But we are talking about the floor. The federal rule really is the floor, and the questions for states is what beyond that can be done.
All right. We have 3 minutes. I'd love to give our panelists, who've all just really given amazing comments, each 30 seconds to 45 seconds to close out on some, what do you want people to take away? Or if there's anything that you feel like has been left unsaid. We'll start here. The first person in my left-hand corner is Betsy, so we'll start with Betsy.
Okay, well, thanks. I think I just wanted to express my thanks to the panel and for the opportunity to participate with this group. And in doing so, to honor the memory of Justice Ginsburg today. Thank you.
Thank you. And Charlotte?
Yes, thank you. I wanted to also just say what an honor it has been to join all of you in the audience and on this panel to talk about these issues that are so near and dear to my heart. And particularly today as we are, mourning the passing of Justice Ginsburg, which has been like a shock through Washington, I can assure you. And, really thinking about the incredibly interesting ways in which this area of the law is going to continue to develop, I think is a perfectly appropriate way for us to remember her today. So thank you for that.
Thank you. Alfonso?
I just want to say thank you. Thank you all for participating. I want to certainly thank all of my colleagues who participated today. And I know that people who are participating today come at these issues from very different perspectives. I would just ask all of us, I know it's difficult because sometimes you're representing employers, you're representing employees, but ultimately to focus on what the underlying purposes of these statutes are, and specifically as it relates to Title VII and as it relates to sexual harassment. We don't want discrimination. We don't want unsafe workspaces. So to the extent we're all collectively working towards that goal, I know it sounds somewhat utopic to say that, but that's what we're fighting for, and I hope that we can, at some point, agree on that principle.
Thank you. And last but not least, Fatima. Thank you.
Well, I just want to say thank you for having me, and thank you to the other panelists and to everyone who joined. And, I have been thinking a lot about one component of Justice Ginsburg's legacy, and it was that sort of period of creation at a time in the 70s when our culture had moved and accelerated forward, but our Constitution for sure and our laws and institutions weren't matching. And I think there's culture speaking to us in this period, and I imagine that it will show up in so many ways in the cases that come before. So I'm just feel grateful to be a part of it.
you all. I absolutely agree. This is a really amazing panel, fitting tribute, fitting to see this sort of, the continuing legacy of the work that so many have done, including Justice Ginsburg, be continued. I learned a great deal from each of you, and I found it inspiring as well. So thank you so much for your comments. Thank you for joining us. We hope that I hope that you've enjoyed the panel as much as I have. So take care, everyone.
Thank you.
Thank you so much. This is Greg Binstock from the City Bar. Just wanted to let everyone know we will be observing a 1-hour break and the program will resume at 1 p.m. this afternoon. Thank you again to this panel.